Hello there, coming to you live from the bunker. This is episode 30 of Watchtower in Focus, the show that zooms in on all things JW, bringing the governing body and its teachings and policies under microscopic scrutiny. This is an episode that we never wanted to make. On January 8th, 2020, the Supreme Court of Montana issued a ruling reversing the 2019 jury verdict, ordering Watchtower to pay $35 million for their part in the abuse suffered by Alexis Nunez at the hands of Maximo Reyes, abuse that could have been prevented if elders had acted on their ethical and legal duty to notify authorities of a pedophile in their kingdom hall. Joining me to reflect on this devastating news is ever-present co-host Mark O'Donnell and friend of the show and JW Survey team member Brandon Fiquette. Brandon and Mark, thank you for joining me.
Thanks, Lloyd. Great to be here. Under better circumstances, I wish, but we'll talk about the good things too.
Indeed. And Brandon, thanks for making time out of your busy schedule.
Yeah, I'm glad to be here.
Brandon, for those who don't know, is actually a former Bethelite. So in addition to the invaluable technical services that he gives to JW Survey, he also has quite some insider knowledge about the organization. But speaking of insider knowledge, when we're talking about the Montana case, I can't think of anyone other than perhaps the lawyers and the plaintiffs themselves who know more about the case than you, Mark. You have been on the ground from the get-go. This must have been a hammer blow to you.
Yeah, I was notified right away, Lloyd, and just a very, very tiny minor correction on your opening statement. It was the 2018 decision rendered by the jury, not 2019.
Of course, yeah.
But it was 2019 that the Supreme Court met, basically a year after the original decision. So they met, and now we're getting the decision months later in January 2020. So, but thank you for that introduction. And yeah, it's a tough day for justice. And I'll tell you what I'm going to do, because I don't know how long our program's going to end up being, but I want to read a statement. I spoke to Attorney Neil Smith this morning, who represented the plaintiffs, Alexis Nunez and Holly McGowan. And of course, there were two other attorneys involved. One is Attorney Jim Malloy in Montana. Obviously, he's pretty devastated as well. But, you know, these men, these attorneys are, you know, rather even-handed in their realization that this is how the law sometimes goes, and we have to accept the consequences of the existing laws that are already in place and how they are interpreted by the Supreme Court of any state or even the Supreme Court of the United States. So we know that in the case of JW versus Watchtower, the Supreme Court wouldn't even accept Watchtower's request to review the or reverse the decision of the lower courts or even the Supreme Court of California in that JW versus Watchtower case. So, you know, that was a great victory for that victim in that case, and it resulted in well over a $4 million judgment, which Watchtower has had to pay to the victim in that case. So in the case of Montana, we are dealing with one state and one set of laws that got interpreted by one group of 7 Supreme Court justices. It is a small thing, while I don't want to diminish the ruling that took place. It is a small thing in the grand scheme of the 50 United States and also the global community of abuse survivors who are seeking to re-legislate these laws that affect whether or not church elders report, whether they can cover that up with their confidentiality clauses. So, I want to put this all in perspective, and we're going to mention some very positive things that have come out of the Montana case. But going back to Attorney Neil Smith, I'm just going to read this statement briefly. And it says, "This is a sad day for victims of child abuse in Montana. Instead of treating individuals and businesses equally in the eyes of the law, this opinion gives preferential treatment to churches, especially the Jehovah's Witnesses, because it allows the Jehovah's Witnesses to write their own laws about when they will and will not report child abuse." And that's a statement from the plaintiff's attorney, Neil Smith. And we'll see that same statement appear in a JW Survey article, which should be up in the next 24 hours, in which I will review some of the things that happened and some of the things that were stated in the decision. It's an 18-page decision. We're going to be posting links to it, obviously, on your channel, on JW Survey, and it's sort of already making the rounds. I've gotten a lot of attention on my my John Redwood Facebook post.
I do have the statement ready if we need to do a screen share at any point, but I think I agree with what you seem to be saying, which is that we're simply at the wrong point in history, aren't we? We're at a point in history where there is still way too much deference in legislation for religion, so that if you are a religion, you get treated with kid gloves, even if you're found to be covering up child sex abuse. So even though Watchtower will be celebrating this and perceiving it, no doubt, to be a vindication of their policy, in reality, this could very much have gone either way. And unfortunately, when we're dealing with appeal courts in America, my understanding is that when it gets to the appeal stage, usually this societal pro-establishment leaning towards helping religions out starts to kick in. And I think that seems to be what we've seen here. Would that be fair?
Yeah, I do think so, Lloyd. And we're going to be discussing some aspects of this case and the decision that's made by the Supreme Court here, so that maybe we can, get viewers to weigh in on it. Obviously, we're not on a live stream, but the comments are certainly going to come. So let's see where to begin.
Well, maybe while you're gathering your thoughts, Brandon, we were talking before we went on air, and you were saying what a hammer blow this was. It seems 2020 is getting off to a rocky start, isn't it?
Yeah. This was definitely not what I was looking forward to hearing yesterday. It felt like a punch in the gut. We got the stuff going on in Australia and the conflict looming in Iran, which seems to be settling down a little bit there, hopefully. But this was the last thing I wanted to hear yesterday.
Do you think that Watchtower will view this as a vindication of their policies?
No, knowing them, they are. It's saving their pocketbook, obviously. I don't think they're going to draw attention to it. We were discussing that before. It's definitely not something I don't think they'll draw attention to, but they will consider it a victory. I mean, every time they've gone and had a pro statement from the Supreme Court, they've considered it a victory. To the point that they gloat about it in a number of their videos. So they'll consider it a victory. A very shallow one, if that. I mean, they're literally hiding behind nuance of the law.
I think wouldn't it be fair, Mark, to say that they've put out a fairly tempered response? I forget what the exact wording was, but I think it was the Washington Post. They're quoted as saying, no one wins in this situation, and our thoughts are with the victims, or something to that effect.
Right. That was apparently they got a hold of Watchtower attorney Joel Taylor, who was the prime attorney from Watchtower that argued this case both at trial and during the Supreme Court. So look, they don't really want to touch this with a 10-foot pole, because what I think in relation to whether they would post anything about it, I really don't think that they will, because the nature of this case is that it draws attention to the fact that they conduct their own child abuse investigations. And so many elders, Watchtower Service Department, elders, the legal department, family members are notified. There is this broad definition of confidentiality, which they are claiming, and which the Supreme Court of Montana feels they are obligated to give Watchtower the benefit of that broad definition of confidentiality. In fact, what the Montana Supreme Court is saying is that if we don't do this, then the definition of confidentiality is going to be so narrow that in itself is going to cause problems, constitutional problems. And, look, Watchtower's made this argument before where, they say, look, you can't just have this priest and penitent model. That's too narrow, because that's giving preference to the Catholic Church. And the Catholic Church model is very simple, that a penitent person who commits a sin or maybe a crime goes to his priest and confesses. And under the confidentiality law, the priest is not obligated to go to the police, although there are exceptions for child abuse reporting in a number of states now. But again, you have this Catholic Church model. And what the Jehovah's Witnesses are saying is, hey,
we want a piece of that.
Well, they're saying, that you can't just apply that law to all religions, because if you did that, then you would be violating our right to the free exercise of our faith. And our faith demands that we have not one priest, but 3 priests. In fact, those are the exact words that Watchtower's chief attorney, Philip Brumley, told me when I intercepted him a year ago at a New York event. I asked him about Montana, and he says, oh, no, that, the judge erred. And basically the Montana Supreme Court is saying, well, he's kind of right. He's saying that the lower court judge, James Manley, made an error when he ruled before the trial even started that Watchtower and the elders had broken the Montana reporting law. So I want to break this down clearly for our audience members, because I know people are very emotional about this right now, and they should be. It's very upsetting to the victims, to the attorneys involved, but to everyone who is a victim of abuse and everyone in the public who cares about victims of abuse. The core issue here is that the Supreme Court is saying that Watchtower was fully within its rights to not report abuse to the police, despite the fact that there is mandatory abuse reporting laws in place. That is the core. They're saying that, and look, you're throwing out the whole rest of the case, because the rest of the case is built on the foundation of the fact that the judge ruled that Watchtower and the elders in Thompson Falls broke the law. You have a law that says clergy, members of clergy, which both sides agree that they're clergymen. The elders did not report the abuse of Alexis Nunez to the authorities when they became aware of it. And that's breaking the law, despite the fact that there is a confidentiality exception, which, maybe I'll pull that up and we can read that language. But this whole argument
wasn't it Holly McGowan who was abused first? And
yeah,
then,
so correct. In 1998, she was abused before that, but well, here's where it gets really interesting, Lloyd, and I've got to pull up that section of the Supreme Court ruling. So the entire trial was built around this notion that Watchtower's argument is that 1998 never happened. They called Holly effectively a liar. They said she's lying. Joel Taylor got up there with a whiteboard and put $signs on the board and says, that is why Holly is lying, because she's claiming that 1998 she reported and Watchtower failed to report that to the authorities, and that's substantiating the case against Watchtower and the elders not reporting the abuse. So look, the argument here is that 1998, according to Watchtower, never happened. However, if we go to the Supreme Court decision, so let's take a look at this 18-page opinion here and see if I can get that up on my screen, and maybe we can share it later.
I mean, by all means, share it now if you can. Might as well.
Sure. Let's see here. Let's get the right copy of that up. All right.
Okay.
Let me know if we have that up on screen.
Absolutely, yeah.
All right. So do we need to get that larger?
No, that's fine. I think.
Yeah, we can see it.
Are we okay? Excellent. All right. So what we're looking at right here is the Supreme Court, State of Montana. This is the 18-page decision filed January 8th, 2020, and it goes through the parties to this case here. So we'll just skip right over that, and it gets right into the opinions. So of course, the opening statement right here describes the case, and it sort of summarizes this in the first paragraph. Watchtower and Thompson Falls appeal the 20th Judicial Court's ruling that they violated Montana's child abuse reporting statute and its order granting summary judgment to the plaintiff Alexis Nunez on her negligence per se claim. Okay, so then it says they also appealed the court award of punitive damages following a jury trial. So just so that everyone understands what's going on here is that first, the case is built upon the fact that Watchtower and the elders broke the law. Watchtower is saying they didn't break the law, but if the lower court did rule that they broke the law, which the judge did declare that before the trial even started, then the rest of the trial was effectively about how much to penalize the penalty, right, for negligence and for malice. So that's when you get into the discussion of punitive damages. We hold that the Jehovah's Witnesses are accepted from the mandatory reporting statute under 41.3.2016C because the undisputed material facts in the record show that Jehovah's Witnesses canon law, church doctrine, or established church practice required that the reports of abuse in this case be kept confidential.
To their benefit.
Yeah. Right. We therefore reverse the district court's grant of summary judgment to Alexis and remand for entry of summary judgment in favor of Jehovah's Witnesses. Because this issue is dispositive, we do not reach the punitive damages award or the Jehovah's Witnesses' other arguments. So, if you recall that, there was an issue over the cap, the $10 million cap, which Lexi's law firm says, look, that's unconstitutional. We really never thought we were going to get to the point where we wouldn't even have to discuss that because the lower court very clearly ruled that Watchtower and the elders had broken the law. And here what's going on is that the Supreme Court is saying, no, they didn't break the law. Yes, there is mandatory reporting. And yes, they didn't report. But according to this section, 41.3.2016C, they are accepted from the mandatory reporting statute because
it really is
confidentiality.
Because if you think about it, it's like if you're a person and you steal a car, you're going to go to jail. But it would be the equivalent of saying, no, Your Honor, actually, I didn't steal the car. I lawfully took it because I'm a religion and that's my religious beliefs. Oh, well, in that case, enjoy the car. And we're talking about something profoundly more damaging here, child sex abuse. And if you can convince society that you're a religion, you can basically do whatever you want.
Essentially.
So, yeah, that's it. And I want to get back into that point a little bit further because there's some things that are stated in this document that are just really appalling. So if you can see item number 3 here, we have a statement. And now remember, this statement was drafted or written by Justice Baker, and every single one of the Supreme Court justices, there were 7 in total, concurred with this. So anything that Justice Baker wrote would have to be very, very carefully reviewed by the other 6 members of the Montana Supreme Court. So having said that, you look at item number 3, it states, in 1998, Holly told Don Herberger, a local elder at the Thompson Falls congregation, that her stepfather, Maximo, had inappropriately touched and fondled her. Herberger directed Holly to 2 other local elders, Ken Wright and Glenn Wilson, who dismissed her accusations on the grounds that they lacked a confession or second witness, which elders require to substantiate report of abuses before taking actions against the accused. I'm gonna stop right there. So the opening statement here, in 1998, Holly told Don Herberger that Max Reyes had inappropriately touched and fondled her. What is significant about this is that the Supreme Court is entering this as item number 3, a statement of fact. Now, this is,
and this was supposed to be questionable in the actual trial. Yeah.
Yes, and that is why the lower court judge ruled that. Well, let's put it this way: the jury had to come to the conclusion that there wasn't enough evidence of the 1998 child sexual abuse, but there was plenty of evidence once they got Max Reyes to confess, or once he did confess. And they have an S-77 disfellowshipping form where the elders outline everything that happened. We also have Holly's letter, I think from 2004, which she wrote to the body of elders. Those were 2 of the 3 pieces of evidences entered into this case. But what is shocking to anyone who reads this is the fact that the Supreme Court is stating that, as a matter of fact, this did occur in 1998. Whereas that was absolutely under dispute, and the lower court judge was not able to substantiate that. I'm not saying it in legal terms, but I think you get the idea. That I feel like when I read things like this, that the Supreme Court did not do their due diligence, that they were entirely focused on, I think, the consequences of their ruling. If they upheld the ruling of the lower court, what would the consequences be of other religions, and how would that affect the view of the Supreme Court? We already have evidence within this document itself that other religions went up against the legislature and actually changed the law when it had been revised. A few years back, they had revised the clergy mandated reporting law, and religions got up in arms about it, and they forced the change so that there was this broad confidentiality exception. So let's read 27. It says, as we interpret the terms of 41.3.2016, the intention of the legislator is to be pursued if possible. The statute does not expressly define confidentiality. In 1991, the legislator amended the reporting statute. It inserted subsection 2H to include clergy in the list of mandatory reporters. It simultaneously inserted the clauses now contained in subsection 6B and 6C, exempting clergy from reporting under certain conditions. So what they're saying here is that they amended this law in 1991, and they made sure that they inserted clergy as in the list of mandatory reporters, so that clergy would have to obey the child abuse reporting requirement. But then, let's see, there should be mention here of what happened in the legislature where the other churches got involved. And so let's see if we can find that statement. I think that's important for people to understand. So
the churches got involved, and it's important to stress that this won't have been for the benefit of children or the benefit of child sex abuse victims. This will have been for the benefit of the church. And what they've done is, if I understand correctly, they've said, okay, fair enough, clergy have to report, but if they deem it confidential according to their religious practices, then they don't have to. Is that fair?
Yes, here we go. All right, here's the statement. So this is found under section 29, and it says, let me see if I'm going back far enough here so we can, So let's go back to legislative history. It confirms the body's deliberate policy choice when adding the reporting exceptions. During the House Judiciary Committee hearing on House Bill 391, the bill proposing the 1991 amendments to the mandatory reporting statute, both the bill sponsor and committee members expressed their intention to avoid interference with the practice of religion. All right, 1991, Montana laws 785, etc. On HB 391, clergy to report child abuse, before the House Committee on the Judiciary. Let's skip ahead. As introduced, the bill included clergy among mandated reporters and added only the provision that subsection 2H is not intended to interfere with the practice of religion. All right. So then here's where the statement is that we want to read. After hearing concerns from numerous clergy members that the bill would entangle the state in the affairs of the church, the bill was amended to add the specific exceptions now contained in subsections 6B and 6C. Now I can pull those up. I don't know that you'll see them on screen unless I do a reshare here.
I mean, by all means, just quote them to us, and I'm sure the viewers can cross-check if you're deceiving us.
So there's going to be a link in the. I've already linked it in the article that I'm working on right now. So 6B and 6C. All right. So here's the exception. 6B says a member of the clergy or priest is not required to make a report in this section if the knowledge or suspicion of the abuse or neglect came from a statement or confession made to the member of the clergy or the priest in that person's capacity as a member of the clergy or a priest. Item 2, the statement was intended to be part of a confidential communication between the member of the clergy or the priest and a member of the church or congregation. And item 3, the person who made the statement or confession does not consent to the disclosure by the member of the clergy or priest. All right. And then there's one more. There's 6C, which is very important. It says a member of the clergy or priest is not required to make a report under this subsection if the communication is required to be confidential by canon law, church doctrine, or established church practice.
Right. Which is basically the one that they got them on, because as far as I'm aware, the information, the really pertinent information, we're talking about 1998, aren't we? Came to their attention through, was it Holly McGowan?
Yeah.
I'm pretty sure that that wasn't in the form of either a confession or communication that they didn't give consent to being spread. So out of all of those criteria, probably the last one where the religion just gets to decide for itself what's confidential and what isn't.
Yeah, and that 1998 thing, I think it's really critical because, look, this is a deal where Don Herberger, the elder involved, and there were two other elders in the judicial case of Max Reyes, but he denied, in fact, they all denied that the 1998 report ever happened. They said it never, ever happened. And here the Montana Supreme Court is identifying 1998 as if
calling
it
them
did
liars.
happen. Well, yeah, I mean, effectively what I would say is not so much calling them liars, is what they're doing is they are stating as fact that 1998 happened. And when they're defending Watchtower in this case, but Watchtower's own people, including their elders, absolutely denied 1998. What that tells me is that they're not deeply invested in the facts of this case. They're more invested in what the effect would be if they rule against the plaintiff, Alexis Nunez, in this case. And I think that's really disturbing.
Well, the whole thing's disturbing. I mean, it's disturbing that a religion just gets to let itself off the hook by deciding, at least in the state of Montana, I should say, by deciding what's confidential and what's not confidential, and who suffers. It's the victim. It's the survivor. It's not remotely in the interests of child safety or child safeguarding. It's in the interests of protecting religion. And as I said at the outset, here we have a clear example of the fact that we're just living at the wrong point in history, because there's way too much deference to religion in American law and in other countries' laws.
Let me point this out too, in terms of while we're on the subject of the Supreme Court's what I would call errors or misrepresentations. If we jump up here, and hopefully you still see that on screen, on page 9, list item 18, here's the statement. And most people are not going to catch this unless they've actually read all the details of the case. And honestly, I haven't reported enough on this case that, or released a transcript on this that people would know. But here's the statement. Dave Chappell is a Jehovah's Witness Service Department elder designated by the Watchtower and CCJW Board of Directors to serve as their representative. And I'll just stop right there. Okay, who is Dave Chappell? I don't know who Dave Chappell is because he certainly was never a witness in this case. Oh, do you mean Douglas Chappell?
Oh, right. Okay.
Douglas
So
Chappell?
we're getting down to incompetence at this point. If they're getting names,
They didn't even get the name right.
Oh,
So,
grief.
Dave Chappell. So look, this is not just a one-off mistake. All right, jump down here. Dave Chappell's testimony.
Dave O'Donnell, are you
Again.
sure about that?
Well, you know, what I'm not sure about is whether or not the 7 members of the Montana Supreme Court, while they should have been watching Law and Order, instead they were watching Dave Chappelle's Comedy Hour, and they had Dave Chappell.
Yeah.
I just think that, look, and they've got to have people who review what they write. They've got to have somebody. Maybe usually if someone is called Dave and you're writing about them in a legal document like this, you would call them David, wouldn't you? They do, oh, Dave. You know, it's just so lazy. You know, you'd think you'd go back and double check your facts because Douglas Chappell was a key witness for Watchtower. In fact, he's mentioned throughout this document in the establishment of the fact that his testimony was that everything was, confidential. All this communication between, the victims and the body of elders, between the elders and the service department and the elders in the legal department, all of it was based on confidentiality. And, he was a key witness in that. They brought him up on the stand fairly early in this trial as Watchtower's representative. And I'll never forget when they sat him down and he couldn't even get his opening words out. He was just mumbling and fumbling and his mouth was dry. And he said, oh, it's because I just ate lunch. And then he admitted to being nervous. And I'm thinking, my God, how did they get this guy on the witness stand as a key witness? But basically the Montana Supreme Court is agreeing with him because they're saying that the other witnesses involved agreed that the process was the church canon process and that it was supposed to be confidential. However, we do have some evidence to the contrary of that. For example, when Peter, who is another victim, who is the brother of Holly and the uncle of Lexi, he testified for Watchtower in this case because he is still an active witness, and they got him to say that it was all confidential. But Attorney Neil Smith also got him to say on the witness stand that his intent was to go to the elders so that they could out this guy publicly. And that he wanted that there was really, look, the Watchtower attorneys prepped him to say this was all confidential,
of course,
information. But the reality is that, most child abuse victims that get upset, they go to an authority figure and they want the perpetrator dealt with, particularly if they're free of his influence. Like, if Peter at one point he got out of the house and he was free of the influence, a lot of victims of child abuse are only able to come forward and do something once their perpetrator has been, handled in some way, whether it's disfellowshipped, arrested, put in prison. This was the same thing with the Arkansas case, where it wasn't until Roderick Watkins was disfellowshipped that all of the other stories started coming out, because the children felt like, they were somehow now protected or vindicated because this man was finally disfellowshipped. Prior to that, speaking out against a church elder, a Jehovah's Witness elder, was unthinkable. And most of the members of the congregation were defending Roderick Watkins because they just couldn't believe that this was true, that their most upstanding elder had committed these, awful sins and molested these kids.
Are
So
there any other highlights from the document? Because it's kind of sickening me just to look at it, especially knowing the incompetence that's gone into it.
Yeah, let me jump down to there are some statements in here. In fact, to tell you what I'm going to do is I'm going to jump over to a little bit different copy. I'm going to jump to a highlighted copy of this, so it maybe is a little bit easier for us to point out.
Okay.
So give me just a moment here. Let's stop the screen share and let's see if we can get hold of another document in this case.
I was doing a little research into the Montana child reporting, mandatory reporting laws, and this is essentially giving them more room than even mental health providers. And according to what I see for child abuse, attorneys are the only ones that are not required to report. The mental health providers, social workers, clergy all reported, but this is giving churches and religions way more room than even a mental health care provider would be in this situation.
So you gentlemen can let me know if that's appearing okay on your screen.
Yeah.
Here, I've got a number of tabs open. So what? Let's see if we can jump over to a proper copy of this that's got some markings on it.
Mark, you're just trying to impress us with how studious you are. I know your tricks.
Yeah, I'm not sure if I call this studious, if not just highlighting insanity.
Sure. We're triggering a few viewers who are used to being judged on how much they highlight certain documents.
Yeah, I know. It's we got to use a different color. It reminds me too much of. I just absolutely hated it when people took their highlighters out and highlighted their Watchtower.
Yeah.
And some of them did it in multiple colors. I thought, well, at least if you use a pencil or pen and put some detailed notes in the margin or something, that's a little bit more of an intelligent operation than just going swipe, 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 swipe. And then you look over and you've got people that have their entire, page is yellow.
Paragraph.
It's like, what's the point? I mean, do you really not remember these things that you have to do that much swiping with the
This Watchtower is so good that every single word is highlighted.
It's all from Jehovah. Yeah. So here's a couple of things that came out. So because I do want to talk about some of the positive things that have come out of not necessarily this decision, but the entire case. Because look, whether or not the $35 million judgment or check is written to the victim in this case, I really think that's irrelevant to what actually took place. We had a multi-day trial in which Watchtower was placed on trial for its role in covering up child sexual abuse, and they openly admitted a number of things that I think would be eye-opening to Jehovah's Witnesses. So here's one of them, okay? So here you have, if you can see that, Jehovah's Witnesses organizational structure and reporting policies, okay? So what the Supreme Court does is they go into describing congregations of Jehovah's Witnesses consist of, and they explain what they consist of, and it talks about a group of men called the body of elders oversee the spiritual activities of the congregation, and they provide guidance. And then it says the parties agree that elders are clergy under Montana law. Now this is interesting because we know from the 2017 Fessler case that, in a bizarre twist, the first 2 days of trial, Watchtower's insanely obfuscating Representative Thomas Jefferson stated that elders were not clergy. And so here we have, on day 3 of the trial, they reversed that and said, oh, no, we are clergy. We're going to stipulate to that. We are clergy as far as mandatory reporting is concerned. Once they declare that they are clergy, then they take advantage of the clergy mandated reporting. But they really want to have it both ways. And sorry, I meant to say clergy reporting exception. That's what they take advantage of, the exception not to report. So they're saying, hey, we're not clergy as far as what they tell Jehovah's Witnesses. The average witness would say, no, we don't have a paid clergy. We have volunteers. They're not really a clergy. But then when it comes to court, we've got a clergy because, and this is the only reason, because they want to take advantage of the exception not to report cases of child abuse, and the only way they can take advantage of that exception is to admit in open court that their elders are members of clergy.
So they'll bend the definition when it benefits them.
Exactly. So they want it both ways. So then they go down to, according to Jehovah's Witnesses, the elders will report child abuse to secular authorities if required by law. Otherwise, they address it internally. So it's funny that they say, according to the Jehovah's Witnesses, because as we know that the witnesses actually rarely ever report unless they figure out that they can't use the reporting exception. They truly want to keep all of this confidential, even though there's nothing illegal. In fact, the law says they should report. And the question is, what would happen if they did report? Well, if they did report, the elders would be doing a service to those victims of abuse, but they don't report. So the organization's policies are more important to the Jehovah's Witness governing body and legal department than the victims of abuse are. So what I find as a significant takeaway, and we'll have to go a little deeper into the document to find this. And let's see here. Here's more of Dave Chappell, aka
good old Dave.
Douglas Chappell.
Yeah.
Okay. So I thought this was significant. It's on page 13. So if nothing else, we come away from the Montana Supreme Court stating the summary judgment record demonstrates that Jehovah's Witnesses have an established process for receiving and investigating reports of child abuse within their congregations, that they consider this process confidential, and that the process necessarily involves multiple elders and congregation members, including the accused, the CCJW elders who provide spiritual guidance, and local elders who conduct the investigation. I just want to let that sink in to everyone, because this is the Supreme Court of Montana openly stating for the record that Jehovah's Witnesses have an established process for receiving and investigating reports of child abuse within their congregations, and that it's confidential, therefore they don't have to report. The very fact that you have an organization, imagine if this said, let's take Jehovah's Witnesses out of the equation. Let's replace Jehovah's Witnesses with the YMCA or with some other business. Then you would have the statement, the summary judgment record demonstrates that the YMCA have an established process for receiving and investigating reports of child abuse. Think about that. What if you went to the YMCA, you took your kids there, and then you heard a court say the YMCA conducts internal investigations of child abuse and that it's all confidential and they don't have to report this to the authorities? I don't think any parent would take their child to the YMCA if they knew that the YMCA knew all about the predators, the perpetrators, that they were collecting, collating, and putting all of this in a detailed database, which Brandon can probably talk a little bit more about. Watchtower's ability to store data in a very secure manner. And, if the YMCA or any other organization did this, what would the public think? What would the parents think? And yet we give this deference, as you pointed out, Lloyd, to religions that no other organization receives.
I guess what confuses me, Mark, is that we've established that Watchtower got let off by the Montana Supreme Court because of an exemption tucked away in the legislation that effectively allows religions to decide what they want to consider to be confidential. So my question is, didn't Neil and the other lawyers anticipate this? Did they not kind of look through the legislation when they were first starting their process and think, oh, this could be a big problem because Watchtower effectively could get let off the hook here?
Yeah, so they dealt with this both in the prior to trial in early 2018. And they dealt with this during the trial, and they, although the trial was much about, fleshing out the facts of the case and getting.
Well, the trial decided that the breach had already been made. Like you say, they've been found guilty on that front. So I'm curious to know why this got missed, including by the judge, by the sounds of things.
Well, the reality is that, so this is an interpretation of the law, and it really did not get missed. So they all, look, they went over this in great detail before the trial. They knew about this. And Judge James Manley looked at the language of the law, and he said, look, and I know he looked at other case law as well, because we have examples in other states where they ruled differently. For example, Delaware. The Delaware judge in the case that we've reported on here at JW Survey, the Delaware case involved a 14-year-old Jehovah's Witness boy and a much, much older 20 or 30-some-year-old woman who they were both Jehovah's Witnesses that were baptized. And they were having sex 50 or more occasions. The mother ultimately found out and reported it to police. The elders did not report it to the police. They kept it confidential, covered it up. The Attorney General for Delaware found out about it, and then the Attorney General sued the Jehovah's Witnesses. And the judge in 2016, the judge in that case in Delaware looked over the facts of the case and said, no, you don't have clergy confidentiality exception. And the judge ruled in favor or against Watchtower, because the Watchtower moved for a summary judgment against the Attorney General. And the judge looked at it and said, no. So Judge Manley in Montana did the same thing. He looked at the facts of the case. And by the way, the Delaware case settled because Watchtower didn't want to go to court. So they ended up writing a check. And that's the one that I ended up flushing out with a Freedom of Information Act request, which got the settlement agreement. But back in Montana, you have Judge James Manley, who read this. Look, the man is a very well-respected judge in the district court in his particular 20th district, I believe, in Montana. And he read this statute differently. And remember, look, the Montana Supreme Court, they're going to be going up. They're afraid of religion. Let's just put it that way. Judge Manley is afraid of no one. He made the right decision based on the fact that there was no confidentiality. This was not the case of a penitent man, Max Reyes, coming to the elders and just confessing something, and then the elders being able to not reveal that to law enforcement. The fact of the matter is that the whole thing was just blown out of proportion. All these people knew about it. Every congregation elder knew about it, not just the judicial committee that disfellowshipped Max Reyes. They all knew about it. The service department, Watchtower, knew about it. Legal department knew about it. Although with the legal department, they do have attorney-client privilege. We understand that. But it's all these other people that knew about it. And then one of the arguments that Neil Smith made during the trial itself was that the elders, they took the information that came from the victims in this case. And what did they do? They not only went to Watchtower and all the other elders, they took that information and went to Max Reyes. And this was a point, he's the abuser. So they confronted Max Reyes. And ultimately, by 2004, he had admitted to the sexual abuse of, I think, Peter and Holly. And that's why, because there's a confession, that's why the elders did disfellowship, but him only because there's a confession. So we have the S-77 disfellowshipping form. So there you go. You know, you've got this situation where they got a confession, they disfellowshipped him. The judge looked at all of this and said, you guys are right. It's not confidential if you take this information and you go to the abuser himself and others and you reveal it.
I guess what you're saying is that
whose confidentiality?
Much like the Bible, you could say, the law is open to interpretation. And James Manley made the correct interpretation of realizing that Watchtower's treatment of this information was confidential in words only and not in actual practice. Whereas the Montana Supreme Court, again, due to ingrained deference to religion, has decided to have a far different interpretation of the law. Would that be fair?
Yes, and here's the document that sort of backs that up. And I agree, Lloyd. It's just like trying to interpret the Bible or any other document. And I do sympathize with the Supreme Court because, look, their job is to interpret the law, and they have to do it dispassionately. I can't imagine that this Judge Baker is so cold-hearted that she wouldn't look at Lexi Nunez and realize that she was, in fact, serially molested by Max Reyes, her step-grandfather, many times over an extended period of time, and just not feel broken to her heart and realize that these elders caused much of that by the fact that it could have been avoided if they had reported this matter to the police and let the police, who are professionally trained, handle the investigation. So here's what I do feel for them in that, but at the same time, what I'm saying is that they're bowing to political pressure. And look, they feel that if they set a wrong precedent, and look, I don't know what the religious beliefs are of these 7 members. I'd like to look a little bit deeper into the political leanings and the belief structure of these 7 members. Perhaps they are sympathetic to religion. And I can tell you that they did go back and look at some Jehovah's Witness case law, and that's mentioned in this document. And perhaps we can talk about that another time, or I'll mention that in my survey article. But they did refer to other case law. Here's what they said here in 29. This court's task is to interpret what is contained in the reporting statute as written by the legislature. We do not opine whether that body could have made a different policy choice that would afford greater protection to child victims. The legislature is the appropriate body to entertain such policy arguments. So if you see what they're saying there, is they're saying, look, that's not our job. Our job is not our job is not to tell you what the law is. Our job is to interpret the law. And if the law says there is an exception, and they look back and said, oh, the clergy got up in arms, they went back to the legislature added these exceptions for reporting, 6B, 6C, whatever they were, then the Supreme Court is saying, well, we have to uphold that.
But surely if it can swing either way, and it's purely a matter of interpretation, you're going to side with victims of child sex abuse over a multi-billion-dollar international organization.
Well, they're not looking at it as the multi-billion-dollar organization of Watchtower. They're looking at it as all religions. And I think we saw something similar in the Canadian Supreme Court.
Well, again, I don't know how you can justify siding with all religions versus actual victims of child sex abuse.
I agree, Lloyd. I agree. It's a problem in our law, and it's a problem because, look, I can't speak for other nations. I'm an American citizen, and we have a country that is still largely Christian-based, although that's starting to shift. But because we're strongly Christian-based, look, I mean, you have so many conservatives that are in favor of President Donald Trump, and he is claiming to be a Christian, whereas in fact, obviously, his morals, his judgments are anything but what most people would consider Christian. So we have a large conservative portion of the United States that is in favor of protecting religious rights, and it's because they don't want. Look, this touches on the establishment law, and it's actually mentioned here in this document. In fact, maybe I could pull that up for those that aren't familiar with the establishment clause. We can whoops, so we do a little search here and just pull that up. Okay, so here we go. So this would be on page, let's get this out of the way. So it's item 30 on page 16, and it says the Establishment Clause ensures that one religious denomination will not be officially preferred over another. And this is the argument that the Jehovah's Witnesses are making. They're saying that, look, you can't just have these laws for the Catholic Church exemption of one priest and one penitent and keep that confidential because, hey, we're a different religion. The Establishment Clause says that you cannot prefer one religion over the other. So the Supreme Court of Montana and the United States has got to jump through these hoops in order to please all of these religious groups, because they all have these different principles. But it's insanity, Lloyd. It's just, you know, and I know, and Brandon knows that it's insanity to be able to buck the law, to buck against the law and say, hey, we can collect all of these reports of child sexual abuse and keep them confidential because it's our established church practice and canon.
Yeah.
It's the law.
I'm just
legalizing
mindful
breaking
of
the law.
I'm mindful of the kind of finite time that we have Brandon for, and what I'd like to do is jump to our concluding comments shortly. Before we do that, Mark, I'm wondering whether you can just summarize how Holly and Lexi are doing, and also what are your expectations in terms of moving forward? Do you sense any appetite from the plaintiffs and their legal representation to in any way contest this decision?
So, you know, I just want to remind everyone that I am not an attorney. I don't speak for the attorneys or the law firm or anyone revolving around this case. So, you know, please don't misrepresent any of my comments. And I'm not saying that to you. I'm just saying that to the public. Don't represent my comments as being representative of the attorneys. So that being said, it does not appear that there will be an appeal to the Supreme Court of the United States. And the reason most likely here is that there are no constitutional issues that the plaintiff, Lexi Nunez, would bring up to the Supreme Court of the United States. You have to have some sort of violation of constitutional law in order to get it heard by the Supreme Court. And even then, they only hear a fraction of the cases that are brought to them. So we're not going to expect to see a Supreme Court appeal. Now, that being said, there are some statements in this document, and see if I can jump back to it, that were also factually inaccurate. And
you're saying that there were factual problems with the determination.
Correct. And I can't tell you what the lawyers are going to do. Look, I mean, they just found out about this. I'll do a quick screen share here and then unshare it. But
this is strange because I understand what you're saying about the Supreme Court and that it needs to be a constitutional issue, but surely there has to be some recourse available if a Supreme Court of a given state issues a decision that contains factual errors. In other words, they're not doing their jobs properly.
Yeah.
Well, that's what they're going to be discussing. So the short answer is that I don't believe there's going to be any appeal available on the basis of the fact that this was not a dissenting. There was not a dissenting opinion. So all 7 Supreme Court justices of Montana did concur with this Justice Baker's opinion. So they all signed off on it. Now, if we had a split decision, and I don't know, you know, what the rules are in Montana regarding that, but you know, if there's some sort of split decision, then maybe there would be some basis for taking another look at it. But I'll leave that for the lawyers. But this was a unanimous decision. All 7 of those justices said, hey, that, you know, they have the religious right. This is their religious practice. You know, if they want to report on child abuse, I mean, you know, conduct internal investigations and not tell the police, well, you know, that's their established church practice, and we can't infringe on that, or we're going to have problems with other religions. So going back to this statement here, though, that's factually inaccurate, at least in my belief, it is item number 8 says the district court granted summary judgment to Alexis. Okay, that part's correct. But then we go down to this statement right here. And let me highlight that. The plaintiffs dismissed their common law. Whoops, I lost the highlight. Okay, the plaintiffs dismissed their common law negligence claims and proceeded to a jury trial on this single claim. All right. So what I'm going to do is just kind of sit back and let the lawyers do what they do, and they're going to discuss it among themselves. But, my understanding is that they're saying that's not accurate, that where it says the plaintiffs dismissed the common law negligence claims and proceeded to a jury trial, that's not accurate. And I also believe there's a difference between negligence and negligence per se. So I think that's something that maybe once I get a little bit more information on, we'll report on.
Sure. And you are, as you mentioned, writing a JW survey article. And as soon as that link is available, it will be in this video description for anyone who wants to check that out. My other question, of course, how are Holly and Lexi doing?
So I have not spoken to Lexi. I wanted to be respectful of the fact that, number one, I don't really like to talk to victims of abuse while there's ongoing litigation. I obviously did spend a good bit of time with them in Montana at the hearing, at the appeal hearing. And of course, I was with them at the trial where we first met. But Lexi just found out like last night, 5 or 6 p.m. And I don't want to speak for her. I can't say, I don't want to say she's upset or not if I haven't spoken to her, and I don't even know if it'd be appropriate for me. I will say that, I think Holly is a very, very positive person, and she knows that a lot of good has come out of this. And I'll mention a few things in just a minute, but they're doing as well as they can. And look, this is sometimes these legal battles get protracted. Unfortunately, this is not the result we wanted, but if nothing else, it flushed out the fact that Watchtower has openly admitted that this is their policy, and they have a corporate policy where they collect all of this information, conduct these informations, and the public needs to know, because without the public knowledge and the legislator awareness, we will not change these laws.
Indeed. So we now go to concluding comments. Brandon, you've been listening to what Mark's had to say. I know you've also done a little bit of research before we started recording. So how do you sum up your thoughts on this bad news?
Well, it's sad, but as Mark was saying, the positive out of it is I think we very clearly see where the law needs to be improved, and the tactics at which Watchtower is using to defend themselves. On one, they're operating out of two different dictionaries. On one side, they're religion is a snare and a racket, but if it benefits us, we're a religion. Clergy is bad. That they're responsible for what's going on in the world. We're clergy if it benefits us. So they're talking out of, we see very clearly they're talking out of two sides of their face. And the room that the current legislature in place gives to religions, it's a blank check. Basically, if you decide that it's confidential, it's confidential, and it checks our boxes. And I know the judges are supposed to be impartial, but like Mark was mentioning, I don't know what their religious beliefs are, but in the back of their mind, they've got something in mind when they're thinking about religion, maybe that one they personally affiliate with or identify with, and that's a tall order to face against. Possibly setting a precedent for many different religions and incurring the wrath of many different religions. So I think we see. My personal opinion is we've got to work hard and change the law and close these gaps that they're taking advantage of for their benefit.
Well said. Yeah, I think we've said repeatedly, this is just a case of us living at the wrong point in history. And, if this was, let's say, a play group or a Boy Scouts or anything like that, if you took religion out of it, you like to think that these judges would immediately see, this organization was responsible for this abuse and they need to pay for it. But introduce religion into the mix and suddenly everything changes. And that has got to be wrong, and that has got to change. Yep. And so, like you say, if nothing else, at least that has been brought into stark contrast, and we can now forever talk about the Montana judgment as a clear example of where the laws need to change. Mark, do you have any concluding comments for us?
Yeah, a couple of things. I want to keep it on a positive level here because we're not hanging our heads in defeat here. The monetary sanctions against Watchtower, we'd love to see that happen because that sends a message to institutions that cover up child sexual abuse. And look, we've already had lots of millions and tens of millions of dollars. We just talked about JW versus Watchtower. Over $4 million Watchtower was held liable for and had to pay that money to the victim in that case. And that's just one case. Remember that Montana is just one case. Remember that this is only the state law of Montana that we're having a problem with. Yes, the exception rule is a problem in other states. We know that. But look at how many successful cases have been litigated against Watchtower in states that also have exception laws, like Delaware. The judge in that case said, no, we're not putting up with that, and rule against Watchtower. So this is, I think, a poor decision from Montana. I think there's reasons behind it, and it's beyond our power. We can talk about it, we can write about it, and I think media is very important in the dissemination of this information. I think people are going to be up in arms about this. They're going to reach out to their legislators, particularly the ones in Montana. Look, I sat in a room when this Supreme Court hearing happened, and there were hundreds of Montana's lawyers. It was the entire Montana State Bar Association was there. These are the people that are the pool of people that get ultimately chosen to become members of the Montana Supreme Court. You know, they sat in that room once with these other Montana Bar Association lawyers. So look, those people know what's going on, and they're also involved in legislation. So I think that some of the good things that have come out of this is there was a widespread acknowledgement that it's horrific what Watchtower and some of these other religions are doing in covering up child sexual abuse. Then yes, the laws do have to change. We have to do it in a way that does not discriminate against religion, but also upholds the law. So let's have a positive takeaway, if we can, about it. And look, when this appeal was held in a few months ago, the Montana State Bar Association issued a multi-page report, and it was a summary. It's online. It's the Montana Law Review online, and it's a preview of Nunez versus Watchtower. I don't know if we can see that, but so here's one of the things that was very positive that came out of this case as a result of what happened in Nunez versus Watchtower. Despite the reversal, that didn't change this fact. And that is, it states here that during the 2019 legislative session, that's this past year, Governor Bullock signed HB 640, which updated laws related to childhood sexual abuse, namely Montana's child abuse reporting statute. The legislator made the punishment for failure to report child sexual abuse a felony and applied it retroactively. The reporting law requires professionals, including clergy, that have reasonable cause to suspect child abuse to report sexual abuse promptly to the authorities. Now, they do mention that there's still an exception in place, so we've already talked about that. And then it says, lastly, an official or institution who is obligated under law that fails to report abuse or reasonably prevent another from doing so is civilly liable for damages proximately caused by such failure or prevention. These changes were in part largely influenced by the Nunez decision that really reinforced what was going on in this lack of reporting. And yet the Supreme Court ended up ruling for Watchtower in the case. So, but we've still changed it to the point where now it's a felony to cover up child abuse. And if the legislature can change that, they can ultimately change or revise the laws so that, you know, Watchtower's reporting policy or the law regarding reporting policy is changed to not favor religions over institutions or businesses, you know, because, you know, Neil Smith's argument and all of the other, you know, lawyers that handle these kind of cases, they're all basically arguing that it's not fair and we need to level the playing field. Another positive thing that came out of this past year is that the Montana Bar Association they awarded both Holly and Lexi with a beautiful plaque for both of them received the award of Persons of the Year for the entire state Montana Bar Association. These people recognized Holly and Lexi for the fact that they came forward with their abuse. They are examples to other abuse victims throughout the world that you can have the strength to come forward. Regardless of this reversal, remember, the judge was in favor of Holly and Lexi and against Watchtower. The judge ruled appropriately in what he thought was the law. The jury sent a very strong message. So ultimately, the people make the laws, and the people decide how those laws are going to be interpreted once it reaches that level. Unfortunately, it didn't happen this time, but it's going to happen again. And finally, we have the vast media coverage and awareness that comes to this case. Look, we've had so much in the past year in the media, whether it's through print or online, even some small documentary programs that mention the Montana case. It's on people's minds around the world that Watchtower was found liable to the tune of $35 million by a jury. Nothing will ever change that regardless of the reversal. And I just want to thank everybody that's been involved in that case, especially, Holly and Lexi. What they did, it took a big chunk out of their life, not only to be abused that way, but to have these men cover it up and then to seek legal representation. And their law firm spent a hell of a lot of money in flying back and forth to Montana and deposing all these people. There was a lot that went on behind the scenes before all this happened. So I just want to thank everybody involved. And there's a positive takeaway from it, that we're exposing child abuse like never before. And you can call it the Me Too movement, the Church Too movement, whatever you want to call it. But this is forcing change for the better.
Indeed. And here at Watchtower in Focus, we will continue to keep the spotlight on the organization, an organization that needlessly puts children at risk. But I do want to thank both of my panelists for your input in this sad episode. But like you say, there are positives, and I, for one, cannot see Watchtower jumping up and down about this too much, because the minute they mention the details of the case, they open up a rabbit hole that they really do not want Jehovah's Witnesses to start going down.
The Google hole.
Indeed. Yeah. So, gentlemen, thank you so much for joining me and making yourselves available. Viewers, don't forget that if you want to watch more videos like this, you can subscribe to the John Cedars channel, but that's all we have for you. And thank you very much for watching.